Good morning, everyone. I hope everyone's doing well today. Thanks for joining us again for our monthly seminar. For those of you who don't know me, I'm Ann Lavelle. I'm the compliance specialist for CTR. In a prior life, I worked as an attorney, a partner in a very large firm downtown. I'm a recovering attorney. That's what that makes me right now. I know that's my standard joke. Some of you are probably sick of it. We are going to tackle a number of topics today, the most important of which is the intermittent FMLA. But as you can see, this is sort of our roadmap for today of what we will cover, because there are some important legislative and court updates that I do want to cover to make sure we're all aware of them and know what the impact may be for employers. And then we will dive into the FMLA. Please feel free to ask questions via the chat or the Q&A as we go forward. And I will try to answer as many as I possibly can as we're talking. And we'll go in that direction. So for those of you who don't know, we hold these monthly webinars, usually on the second Thursday of the month. Next month in August, we're having cocktails and compliance. And I sound so much better if you have a cocktail. So please come out. I am told that it's going to be at a place in Cranberry called Turn, I believe, which used to be the old Quaker Steak and Lube. It's a golf place. I don't play golf. In fact, I cheat at mini golf. That's a different story. We'll talk about it if you come to the compliance seminar. And it should be a good time. So we'll have some hors d'oeuvres, I think, and some fun stuff to do. All right, everybody, again, please feel free to ask questions as we go along. This is our roadmap, so we're going to dive right in, assuming I can get technology to work, which isn't always my friend. Let's talk a little about the new stuff that is out there. First, this has made the news, so I'm sure everybody has heard about this. There was a U.S. Supreme Court There was a U.S. Supreme Court decision involving affirmative action for universities. Essentially, what the court said was you can't do affirmative action anymore. You can take into consideration the person's background and history as it relates to race or gender or whatever social issue may have adversely or positively impacted the person. So if I'm a student applying to Harvard, I can write and say, hey, you know, because I was female or because I was a minority or whatever it might be, I have overcome certain challenges and that would make me a good student for your school. However, you can't have affirmative action and say, hey, I sort of get extra points because I'm a certain race or because I'm a certain gender or whatever it might be. In my case, it might be a certain age, but in any event, not permissible. So a lot of people have said, well, that's interesting about colleges and universities, but what does that mean for me as an employer? Because a lot of employers have dived into the diversity, equity, and inclusion world to try to enhance their workforces. And I always try to stay as far away from politics as I can on these things. But what we're looking at now is sort of a floodgate of cases that started before this decision because they thought the Supreme Court was pretty conservative, that challenged really large companies that had these DEI initiatives. So we already have cases against Amazon and Nike and other huge companies out there that have DEI initiatives saying, hey, you cannot take race into account. For instance, apparently Amazon has a program that if you're an African American or Latino minority, and you want to be a driver for them, they will pay you a bonus up to $10,000. That is not available if you are a non-minority. And so this has been challenged. Now, the first thing to recognize is just because the Supreme Court had this decision about affirmative action, the laws governing universities are different than the laws governing employers. Some of the concepts are similar, but it's different laws. So right now, DEI is still fine within a workforce. And a lot of people might say, hey, it's a good thing to encourage. It's a wonderful thing to encourage. Where I think we're at this point is we're going to watch those cases involving Amazon and Nike because I think the court will probably pare down some of those DEI initiatives. They may say, for instance, with Amazon, you can't make the bonus based on race, even though you're trying to encourage minorities to be drivers for you. But they may also say, hey, when you're hiring, if Anne Lavelle comes along with a really compelling story about, growing up as a certain race or gender or whatever, you can take that into account when you hire her or don't hire her, whatever it may be. So something to keep an eye on as you look at your own DEI initiatives. Something that's not on this list that I also want to talk about is there was a recent US Supreme Court involving religious accommodations. You may have seen that. So for the last quarter of a century that I practiced law, we always told employers, hey, if somebody requests a religious accommodation, it has to be only a de minimis impact on you, basically, or you can deny it. That was the law. And the Supreme Court sort of upended that and said, we don't like the de minimis standard. It has to be sort of a substantial impact on you financially or with respect to scheduling or workloads or whatever it might be before you can deny the religious exemption. So, or accommodation. So people who request like Sundays off or Saturdays off, if they're a Seventh-day Adventist or whatever it might be, the standard now is in their favor to say that accommodation, that scheduling accommodation or whatever it might be, they want to go on a mission trip, something like that, they want a week off for that, you've probably got to grant it unless you can show it's a substantial hardship on your organization. Very different legal standard now for religious accommodations. It's more like the disability accommodation standard. Something I also want to point out, and everybody's probably like, why does she have Illinois up on this PowerPoint slide? Did she forget where she lives? No, Illinois, I recognize most of us are in Pennsylvania or Florida or the East Coast, but the Illinois notice law is something that I think is going to come down the pike for everybody. So we've got a lot after COVID of at-home workers, right? It's a new world out there. And the US Department of Labor, as well as most state labor departments, have said, hey, with respect to these notices that you have to post, like the EEOC notice or the DOL notices or whatever it may be for state or federal, you have to post them in a conspicuous area where employees are at. Well, if I'm at home 99.9% of the time, where is that? You can't really come into my kitchen and be like, hey, nice double oven, but we're going to put a notice sign on top of it. What Illinois has said, and where I think this is headed for everybody, and it's really a good practice, is you have to send it electronically. You have to post it electronically on a place on your, like if you have an employee portal on your website, it makes sense to put it there. You can put this on CTR's information as well, but you should have somewhere an electronic form of that notice, because presumably whoever is at home working is on a computer and will see the notice that way. So it's a good practice. Last but not least, with our busy court and legislative system, the Pregnant Workers Fairness Act took place. This will impact every single employer out there. Anybody who has 15 or more employees. Basically, you have to provide a reasonable accommodation to the woman if they have limitations. What is reasonable? I think employers are going to have a very difficult time saying that anything is not reasonable, because if you look at a pregnancy, and I've had several of them, I have multiple kids, it's a limited amount of time, right? Even if the restrictions come very early in the pregnancy, it's less than a year, right? We're looking at 40 weeks, something less than that, because you're not going to get it on day one, probably. It's hard to show that a limited time of accommodating somebody is unreasonable for most employers. The types of accommodations that this law anticipates are time off, even if they're not otherwise entitled to it under the FMLA or state law. Lifting restrictions. So if I get a lifting restriction in my 6 month of pregnancy, that's going to last for the next 12 weeks, it's really difficult to say that that's unreasonable for an employer to accommodate, even though it means that Joe, my coworker, has to now lift things for me. Because again, this is a really short term in the greater scheme of things. If you're pregnant, it may not seem short term to you. That's not for the women out there. But it is, in the greater scheme of things, a short term accommodation. Sitting accommodations is another one. Hard to say why I can't have a chair to sit in if I'm a cashier. In fact, if you're out in California, it's required. So different things like that, you cannot just say no to. You have to look and say, I must grant it, even if it shifts some duties to other employees. And even if it's a bit of a burden, unless it's an undue hardship to me, which is a very high legal standard to meet. Looks like we may have a question already. Okay, I'm glad you're going over this. Yeah, hopefully it's helpful to everybody. Does this include sites that post job openings? I read an article that said websites had to have the posters available to applicants. So again, Illinois law doesn't say that. The posters are supposed to be in a conspicuous space for employees, so not necessarily your applicants. However, it's a good practice for applicants to at least have what I call an EOE statement, an equal opportunity employment statement, somewhere in the documentation of what you're showing to the person online to say, hey, we're hiring for an IT specialist. Here's the qualifications, whatever it is. I know I'm not getting hired for the IT position because I break technology, but at the bottom it says, hey, we're an equal opportunity employer. We hire without regard. And then you put in the laundry list of covered, I am blanking all of a sudden on the word that I want to use, but on the classifications that are covered under employment law. So no, you don't have to go and post with the wage and hour posters and everything like that in your job posting on monster.com or indeed.com or wherever, but it's good practice to have like an EOE statement on there. So great question. All right, let's move into the meat of our topic today, getting away from everything that the court and the legislature has done recently. Just keep in mind the Pregnant Workers Fairness Act, because that I think will affect just about everybody on this call. All right, I'm going to assume for purposes of this discussion, although I'm happy to answer questions, that everybody has a basic knowledge of the FMLA. You know whether or not you're an FMLA employer. You know the basic hours threshold and work time to be covered. Basically, if you have 50 or more employees, you're an FMLA employer. And basically the employee, if they have worked at least 12 months, does not have to be consecutive, always keep that in mind, and has worked 1,250 hours within the last 12 months, is eligible for FMLA if they have a qualifying condition. The thing that drives employers, I think, a little bananas is intermittent FMLA leave, particularly if you can't see the condition. So psychiatric mental health conditions, I think, are particularly tough. If I break my leg, you can see it. And I have done that before in the past. And trust me, everybody could see me with my crutches. But if I have a mental health condition, it's more difficult to see and appreciate perhaps the need for leave. So a lot of these cases involve mental health conditions. We're going to go through them. Again, if you have questions, please feel free to ask. So the way I'm doing this today is we're going to talk about some very recent cases, basically within the last 12 or year or two, 12 months, talk about where the employer went right or wrong and how things worked out for them. So let's dive in. The first is out of the Sixth Circuit. Just to briefly explain the court system, and probably a lot of you have heard this before, in the federal court system, which is where these cases always end up, or like 99% of them end up, you have district courts, you have circuit courts, and then you have the Supreme Court. So this case, for instance, is out of the Sixth Circuit, which is a conservative circuit. And this means it's one step below the Supreme Court. So this case went pretty high up within the judicial system. We in Pennsylvania are in the Third Circuit. So some of these cases are not what we call binding on us, but they are persuasive precedent. And however one court rules, usually all the other courts fall in line with a couple of exceptions. So this case, we have an employee who has a mental health issue, major recurrent depression, anxiety. And if we look at the statistics out there right now for health conditions post-COVID, this is a really common problem. This case started pre-COVID, but you should expect to see this in your workplaces. They're on a performance improvement plan for attendance. They have poor attendance. This happens to be a unionized workforce. So part of this case discussed the fact that the employer was ready to terminate this employee, but because the union got involved and sort of begged for a second chance, the employer took pity on the employee and said, okay, we'll give you another chance. We'll put you on sort of a last chance agreement. Your attendance needs to improve. You got to step it up. The employee turns around right after they get put on the PIP, the performance improvement plan, and says, hey, I need FMLA for my mental health issues. Now, if you're the employer, a very common reaction to this is suspicion, to say, well, hey, we just gave you a second chance, and now all of a sudden you're telling us you want FMLA. Another lens to look at this through is oftentimes employees are hesitant to tell employers about mental health conditions. And these prior absences, although we don't know for sure in this case, may have been mental health related, right? Except this employee didn't say anything until they were in a heap load of trouble. And now they say they need FMLA. And that's a very common way for these cases to play out, is the employee calls off, blows the attendance policy somehow, and doesn't tell you that they've got a problem until they're about to get terminated or until it's pretty serious. What do you do about that? Well, if you want to be proactive, one of the things you can do when it gets pretty serious is you can say, we have policies and stuff to help you if you need help, right? Just think about this, both ethically and if you had to defend this in a court of law, you don't want to look like a jerk, right? You're going to lose the case no matter what the facts are if you look like a jerk. So, bad facts make bad law. You want to look like you've been proactive, and hopefully ethically we want to be proactive and say, look, we've got these policies if you need help. If the person says, I don't need help, you look great in a defensive posture, because you can never prevent a lawsuit. You can only defend one. That is the wrong question to ask, by the way. If you call up counsel and say, blah, blah, blah happened, some tale of horror about an employee, and can I terminate them, but I don't want to get sued? Wrong question. And any attorney who tells you you won't get sued is lying to you, because you can never prevent a lawsuit. You can only defend it. So from a defensive posture, if you've been proactive in handling this employee, you're going to look better. So this employer was large enough, it had a TPA, a third-party administrator, who handled their FMLA claims. And that can be a great thing to have, because they know the FMLA inside and out. They take a burden off your shoulders. It's them looking at things rather than you. And so it can be a good thing. So they had a TPA. The employer, when they had the intermittent leave certification, approved up to 4 days, which was consistent with the certification. And that, by the way, is something to iron out at the beginning of an intermittent leave, because you're going to get some sort of certification that says this employee needs a certain amount of time off. In this case, it was 4 days a month. If you get a medical certification that says the duration is unknown, or anybody's guess, basically, or the amount of time off is anybody's guess, or how frequent or when it's going to occur, that's an incomplete and insufficient certification. Do not accept it. I understand doctors don't have crystal balls, but they're educated people, and it's the employee's obligation to give us a reasonable certification that we can operate with. We can't operate with a certification, a medical certification that says unknown or to be determined or something else like that. We need a reasonable, educated guess. The employee can always provide another certification that they need more time if it turns out that the doctor's first guess was wrong. If they said 4 days and the person needs 100 days, we can go back and relook at it. But we need something. So don't accept certifications that have vague time periods like unknown. That's a huge mistake. So this employer has done the right thing. They have 4 days a month. Everybody seems happy with that. In December, because that occurred in October, in December, the employee calls off 3 days in December and 1 day in January. He doesn't reference that any of those absences are FMLA related. He says he's not feeling well one time, another time he says he has a flare up, and the other 2 times he really doesn't say anything. The other sort of interesting part here is the TPA had a letter that they sent to him that the court pretty much hit the TPA over the head with. So be sure you get a good TPA. And basically said the letter was so incoherent that the court could not understand it about how to call off for FMLA absences. Should not be that difficult that the court cannot understand the letter. The TPA told the employer to terminate this guy. The employer terminated. Who gets sued? Not the TPA, the employer, right? So even if you have a TPA, the lawsuit is always on your shoulders as an employer. What does the court say? The court says, bad employer, you lose, because the employee doesn't really have to use magic language to call off. They've already put you on notice. These time periods were within the time periods that you approved for FMLA. And if you had a question about it, what should you have done? You should have been proactive and asked. You shouldn't have assumed that just because the person didn't follow this apparently very complex letter that was incomprehensible from the TPA, that this was not FMLA qualifying. And you, employer, have the option to override your TPA. That's important to know too. You can't just blame your TPA for something. And you should have looked into this more if you had any doubts before you terminated them. So the employer loses this case. All right, let's move along. Don't worry, the employers don't lose all of these cases, just some. All right, we have another one out of the Seventh Circuit. This is Chicago. It actually was in the state of Indiana, but the Seventh Circuit sits in Chicago. So we have spouses that work at the same automotive plant in Kokomo, Indiana. Both have FMLA qualifying conditions. Now, if I was an employer, that might raise a little bit of a red flag for me to begin with. It's not impossible that both spouses have FMLA qualifying conditions, but if I'm going to enforce FMLA rules and regulations, I'm going to look for the obvious cases that may have fraud or questionable conduct involved. This employer has a TPA as well. So the wife has FMLA time for anxiety and IBS. The husband has it for back pain, anxiety, and depression. These are not conditions you can see, right? The outside TPA finds that the couple took overlapping FMLA more than 20 times in 1 year. Does that raise red flags for anybody? Well, it certainly did for this company and for this TPA. The TPA tells the employer, unlike the last case, the company calls these two in separately to ask about why there's such a coincidence, winky-dink, in their time off. Neither employee can explain why they've had more than 20 times that their FMLA overlapped. The company suspends, does not terminate these employees for FMLA fraud, basically, or abuse. What does the court say? The court actually sided with the employees, or I'm sorry, with the employer. Goodness, I have not had enough caffeine this morning. The court sided with the employer and said, look, you did everything right, employer. You granted the FMLA. You took a look at how it was being used. Unlike the last case, you called the employees in when you had a question mark about how it was being used. And neither employee could explain the coinky-dink that they're taking time off. And that raises a red flag even to this court, which tends to be more liberal. And that something may not be kosher here, and you were right to suspend them. Something I want to point out about this case, it's great that the employer won, right? By the time you get through the district court, so the suspension of these two people, they probably lost a couple thousand for being suspended. It wasn't that long of a suspension. They still had their jobs, yet they still sued, because you can get additional damages beyond just the money you've lost in wages from cases, right? There's emotional distress, there's punitive damages, there's all sorts of things that you can get in additional to the wages you've actually lost, because the wages often are de minimis compared to everything else. So an attorney clearly took this case. By the way, I have heard in the past people say, oh, no attorney's going to take that case. They only lost like $2,000. No attorney's going to take it. The attorney's taken on a contingency fee basis. It's not costing the employee anything. It's costing you a lot of money to defend this, but it's not costing them anything. And this is like red car, blue car type of claims for plaintiffs' attorneys. They will take these cases. So it's foolish to think that an attorney won't take this case. And it's important to note, by the time they got to the Seventh Circuit, that means they went through the district court level, they went through the Seventh Circuit level. The employer has hundreds of thousands of dollars in legal fees in this case. So they won. They may have had employment practices liability insurance, which I highly recommend to help offset the cost, but it's also your time and headache of defending this. They clearly decided that this was an abuse case that was worth defending. Always pick the cases that are abusive to try to get everybody in line in the workplace, so you don't open up the floodgates of litigation or the floodgates of people trying to abuse FMLA. But this was an expensive victory for the employer. It was a victory, though. Okay, moving along. We're back in the Sixth Circuit up in Michigan. We have a guy, again, with psychiatric issues, or a gal, also had chronic pain. Again, conditions you can't see. Applied for intermittent FMLA. They were granted 48 hours per month over the next 5 years. So hopefully what the employer has been doing during these 5 years is continually getting new certifications at the appropriate times, new medical certifications to show the continuing need for leave. You don't just get one certification and that lasts for 5 years. That's not the way it works. They utilize more than 400 hours in 5 years. Now, if you do the math, that's within the 48 hours per month limitation. So the manager, and again, this is where your first level supervisors, they mean well, but sometimes they cause problems. The manager tells HR that he thinks the employee is utilizing FMLA to extend weekends. And sometimes you do see patterns like that. You see every Friday, every sunny day where it's like 80 degrees and good pool weather, every Monday. Now let's think about that for just a second. That seems like it would be suspicious. But if I have a mental health condition and I'm off every Monday, is that really suspicious? Maybe I'm so depressed about having to go to work every Monday, and probably now everybody on the call is going to sign up for FMLA leave, that it makes sense that I struggle with Mondays to get to work. So although certain things may seem coincidental, if we dig a little further, sometimes there's actually a justification for it. HR places the employee under surveillance. In other words, they actually sent private investigators, and we used to do this when I was practicing, if we had a case that we thought there was abuse, out to videotape the person. And sometimes we would get great evidence from it, and sometimes we would not. In this case, they don't get any good evidence. They have multiple days of surveillance that didn't yield any inconsistent conduct with FMLA leave. Now, long ago when I was practicing, not that long ago, a couple of years ago, there was a similar situation where the employer sent private investigators out to look at what an employee was doing who was using intermittent leave and kept leaving early. What did they discover? She was going to the hospital. Now, if you get that type of feedback back from your private investigator, that has to put things in a different light. And if you actually get sued in the future, that's going to be discoverable that you had private investigator out there looking, and the person was not only doing things that were consistent with the FMLA leave, they were actively seeking emergency medical help. So anyway, nothing's inconsistent. Then one day they get maybe lucky or maybe not. December 14th, the employee takes FMLA leave. She goes to the dentist, gets a haircut, lunch with a friend, a holiday party. They had dinner and drinks. This absence takes her over the 48-hour threshold for that month. The employer questions the leave. So in other words, they bring her in, they do the right thing. They question the leave and they say, hey, what in the world was going, look at this videotape. What? I'm old enough, it's a videotape. What in the world is going on here? And this doesn't seem consistent with your health condition and you're over the 48 hours. In response, the employee submits a note and a new certification from her therapist saying that the leave was necessary, medically necessary, on the 14th for her to go get her hair cut and attend the holiday party because, you know, she is depressed and those things cheered her up. So it's good for her psyche to go do these things. So the employee submits this note and the new certification justifying this absence, and the employer terminates. Does the employer win? I would love to see, if we were live, a show of hands here. The employer loses, and here's why. Once the employer has the new certification saying, hey, more than 48 hours is appropriate, and this absence on the 14th is also appropriate for the haircut, lunch, holiday party, etc., the employer cannot submit or its own judgment. The employer has no medical knowledge, right? You and HR are not medical experts. They can't supplant this medical certification with its own second guessing that this wasn't necessary. What they could have done and what they should have done was get a second or maybe even third opinion, because gosh, this seems like abuse, right? Maybe it's not, but it's raising a red flag. If the employer had gotten a second or third opinion that contradicted this therapist and terminated, they could have won this case. But just saying, hey, we don't believe your therapist after you submitted this note, and we're not medical experts in HR, you're losing the case. All right, I'm sure I'm making everybody who's an HR person happy right at the moment. Again, if you have questions, please feel free to ask. Okay, here we go. This is out of Florida. This is a district court in Florida. Florida gives us lots of good cases. We have an employee who's approved for intermittent FMLA leave again. The management employee who approved this discloses the medical condition, which happened to involve this guy's reproductive organs, to coworkers to help explain why the employee is out and why the other employees need to quote unquote pick up his slack while he's gone. Where do we start with the problems here? Okay, the first issue, this is a really common scenario where the other employees are complaining that they have to pick up slack, or they don't understand why Joe is out, or whatever it is. They're griping, because we know employees gripe, right? And they're upset that they have to do this. And so to explain things, sometimes managers are like, well, if we just tell them that Ann has this problem, they'll be more understanding and they'll accept better their obligation to help this guy or gal when they're out on leave. The issue with that is that the Americans with Disabilities Act, the ADA, prohibits the sharing of medical information in these situations. You can only share it with people who have a need to know, and the coworkers under the law do not have a need to know. All you can tell them is, hey, Joe is out or Ann is out on a medical leave, and these are your new obligations while Ann is out. That's it. You don't discuss the condition. It's none of their business. They do not have a need to know. And right now we have a violation. And of course, these employees proved that they were particularly mature. And when the coworker would return in between leaves, the coworkers would ask how he was doing, which that's fine. Somebody can ask that. But they'd also couple it with some crude jokes and gestures. The employee was embarrassed. He never lost his job. He sued for interference or retaliation. Oftentimes, the FMLA retaliation claims are worse than the original claim of not giving FMLA because it shows sort of a intentional mindset. He won because the employer had given out the medical information, which they should not have done, to the other employees. And when this guy started having problems with his coworkers being kind of crude, the employer took no steps to curb that behavior, which they should also have done. All right, we have a couple of questions that came in. Let me see if I can answer. How often should you get a certification? So it depends on the length of the original certification, how long you need to wait. So if you accept an original certification that says this condition is going to be for 6 to 8 weeks, you're not going to get another certification until after that occurs. At least yearly, you're going to get a certification. Okay, great question here. Does a first line manager have the right to know about the leave? So let me parse this question out a little bit. Yeah, absolutely. They have the right to know that Ann Lavelle is on FMLA leave. Do they have the right to know that Ann Lavelle is on FMLA leave because her reproductive organs are failing her? She's over 50 and she's just a basket case. By the way, after you hit 50, I have decided I am falling apart every which way, but that's a different story. No, that first line and supervisor probably doesn't have the right to know what my exact problem is, right? You can tell them, hey, Ann Lavelle is on FMLA leave. Here's what it's going to be, right? She can miss up to 48 hours a month. Whatever we've decided is the right amount of time. That first line supervisor doesn't need to know the exact details of my condition, whether it's an quote unquote embarrassing condition or not. And in fact, you probably don't want that first level supervisor to know because it's a great defensive strategy. If you haven't told them, they can't share the information. And that's always the danger. Those first level supervisors, God bless them, they're trying to get the job done, right? They also tend to be a little bit buddy-buddy with their subordinates. And sometimes they'll be like, hey, off the record, the reason Ann is out is because blah, 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 blah. You don't want them to be able to do that. You're actually protecting them as well as yourself that they cannot reveal the reason if they don't know. All right, let me move down. We have another question. Is sharing absence as FMLA leave also protected? Okay, no. So if you say they're on an FMLA leave, I don't view that as breaching the privacy, right? We're saying they're on a medical leave or an FMLA leave. We're not giving out, well, it's an FMLA leave because Ann threw her back out because she's over 50 and she's old and that happens to old people. No, that's, I don't think, an issue. We can say it's an FMLA leave. We just don't dive into all the nitty-gritty details. All right. How do you handle salaried exempt associates' pay when they take intermittent FMLA, considering they have worked some hours in a given week? Are you allowed to deduct those days on FMLA leave? Great question. Yes. So that is one specific exemption or deduction that's permitted under the FLSA, the Fair Labor Standards Act. So just a little background here in answering this question. Typically, if you have somebody who's salaried exempt, that means you're paying them a set salary each week that does not vary based on the quality or quantity of hours worked. If you vary that, if you take deductions, you lose the exemption and you owe them overtime. That's the standard rule under the FLSA. The FLSA recognized that intermittent FMLA leave should be an exception to that general rule. And so let's say Ann Lavelle, has migraines and may come in late up to 4 hours a week. And I do that. So on Wednesday, I come in 2 hours late. I still work maybe 6 hours, but I've missed the first 2 hours of the morning because of my migraine. You can deduct for those 2 hours. That is permissible. Now, the the FLSA and the FMLA also require that you take the deduction in the smallest increment that your timekeeping system can handle, which cannot be more than 15 minutes. So if I'm out for 2 hours, you can't dock me for half a day. You can dock me for 2 hours if that's the right amount, or 2 hours and 15 minutes, or 2 hours and 5 minutes, depending on how this looks. And you do have to keep a record. You as an employer have an affirmative obligation to keep a record of that time that I have missed. Some of the issues you get into with salaried employees is, what if I come in 2 hours late and stay 2 hours more? Where are you at that point? And so you got to look at those issues a little bit more carefully when you have somebody who is sort of making up flex time, whether you're going to permit that or not, and for that particular condition. And keep in mind, in addition to the FMLA, you have the ADA, the Americans with Disabilities Act, which might require you to allow me to have flex time in certain situations. That's a whole nother seminar. Okay, I hope that helps and answers the questions we've got so far. Those are great questions. Let's move along from our coworker who had his condition announced, and we got another Florida case because, again, Florida gives us lots to work with. We have an employee out on FMLA leave, intermittently. Again, coworkers say, hey, she appears to be enjoying her free time away from work, and they're kind of teed off that they have to do her work while she's out. They're complaining. Here's the first issue. You need to shut them up. I know that's difficult. I know I put that very crassly, but that's really where it's at, because this is retaliation. Assuming that we have decided as an employer that this person has a legitimate need for FMLA leave and we have granted the leave, then we shouldn't let people be complaining about it. I know that's hard to do, but this was running rampant in this workplace. When she returns, after one of her little blocks of leave, they hold a staff meeting to discuss the coworkers' concerns, and they're all upset that they've had to pick up her duties while she's at, and they're all talking about it and blah, blah, blah. She gets upset. She basically mouths off during the meeting and tells them that this is wildly inappropriate, except she doesn't use that nice language, and they terminate her for insubordination. Do they win? No. Because again, what are they doing here? They are way off base. They should have shut down the coworkers when this started. They shouldn't, and you don't have to like discipline everybody. It can be a conversation. We're here to support Anne. She's out on leave. I want everybody, we're a team, rah, rah, rah. Everybody's here to support. I don't want to hear it. If you don't like it, this is the law. This is what we're doing. We don't hold a meeting to let them air their grievances about this employee with the employee in the meeting, who then gets upset, probably justifiably so. So they lose this case. All right, here's a slightly different one. This is a U.S. Department which enforces the FMLA leave violations. Opinion letter. This is the first one they've issued in a couple of years, so it's kind of interesting. And this is a situation that comes up all the time that employers absolutely hate. It's indefinite intermittent FMLA leave. And by indefinite, I mean, I use a small amount all the time, basically. But because I only use a small amount, I can drag it out all year or almost all year and still have enough hours for next year's FMLA leave. So basically, I get FMLA nonstop for the rest of my work life with you guys. Employers complain about it. They hate it. In this particular situation, the employer wrote to the DOL. Large employers will do this when they're upset about something or want clarification on something, and said, hey, we have an employee who might not be able to work 8 hours a day. They might only do 7 hours. And yet they'll still have enough time to re-up for FMLA leave in the future. By the way, this applies to overtime too. If you have mandatory overtime and somebody says, I can only work 8 hours, that's an FMLA intermittent leave situation as well. The DOL recognized that this could be indefinite leave, basically. You'll never get this person to work a full 8-hour day. And guess what they said? The DOL says that's completely fine. You cannot fire that person or in any way interfere with their FMLA just because it's an indefinite leave where they use just small increments now and then. They may use the full 12 weeks and little itty bitty increments all through the year. And the next year they have enough time, they get FMLA again. They're using tiny little increments again. Absolutely okay. And the other thing they pointed out is not only is it okay under the FMLA, but this is not abuse of FMLA by the employee, but under the Americans with Disabilities Act, this may be a completely appropriate, reasonable accommodation regardless of the FMLA. So even if the person didn't have FMLA rights, the ADA might say, hey, Ann's got some condition and she can only work a 6-hour day, not the 8 hours. That shortened work schedule may be a reasonable accommodation. So something to keep in mind, the FMLA is not the only thing out there you need to be worried about. There's also state and local laws too, that again, that would be a different webinar that you need to pay attention to as well. All right, this one's out of Philadelphia. So for everybody in Pennsylvania, this case is in your backyard. So the employees on intermittent FMLA leave, they're pretty young. It again is for a mental health condition that you can't see. They're also in a rock band called Flabbergasted. Interestingly enough, the FMLA leave dates coincide with the concert dates, both before and after, because the concerts would go into the wee hours of the morning. They get surveillance video of this employee singing his little heart out or screaming his little heart out, depending on how you look at heavy metal, during the concerts, and they terminate him. What does the court say? The court says, yeah, that is so wildly different than what you would think somebody could do. And the dates are so coincidental that we agree with the employer that this is FMLA abuse. And so they lost. Again, they got sued. They were well positioned. They still got sued. So always have a safety net with insurance. All right, out of Texas. So the employees on intermittent leave, the leave was requested almost immediately after a negative performance review. You see this all the time too, or I shouldn't say all the time, but with some frequency. And again, we can debate whether or not the employee finally decided I need to tell somebody I need help, or whether they're just trying to game the system. Sometimes it's tough to tell. They attend a Beyonce concert in a luxury suite the same day as one of the leaves. The employer gets video of it again. The employer terminates. Do they win? Yes, they do. Because again, the behavior was so far out of the norm. And the employer in this case called the employee twice to try to discuss why this person might be able to attend a Beyonce concert in a luxury suite when they were out on FMLA leave for mental health conditions, and the employee blew them off. You are extremely well positioned if you reach out and the employee blows you off, because it shows that you did your due diligence, but the employee was unwilling to cooperate. And so they won. All right, we're going to switch to the DOL fact sheet now. They have some interesting examples of how the DOL believes life should go in these situations. And it's worth talking about for a few minutes. So in this case, we have 3 workers. And the employer provides a bonus to employees who are paid, who work or are paid for 40 hours a week. So there's 2 different conditions here. You either work or you're paid for 40 hours and you'll get the bonus. And so we can see here, Kathy works 38 hours, uses 2 hours of unpaid leave to have lunch with a friend. She's paid a total of 38 hours for the week. I'm sorry, she uses 2 hours of unpaid leave. She's paid for 38 hours for the week. She's not eligible for the bonus. There's no FMLA issue here at all. Serenity works 38 hours and uses 2 hours of paid sick leave to see the dentist. That's not an FMLA qualifying reason, most likely. She does get the bonus because she's paid for 40 hours a week. Then we have Ray, who works 38 hours, has 2 hours of intermittent FMLA leave, for which he is paid using the sick leave policy. He also is eligible for the bonus. All that makes sense, right? Because he's the same qualifications. as everybody else, right? If you get paid, it doesn't matter the reason how you got to that number that you got paid, you got paid. But what happens if Ray works 38 hours and uses 2 hours of unpaid FMLA leave? We are not supposed to ding people for taking FMLA leave. However, this employer had a really interesting way they wrote the policy. It said you have to have 40 hours of paid time. In this case, Ray's not entitled. We're not dinging him for the FMLA leave because, and this is critical, if we look back here, Kathy had 38 hours and 2 hours of unpaid time and didn't get the bonus. So it doesn't matter why we had unpaid time. It's the fact that we had unpaid time. We treated everybody the same, whether it was FMLA or not. Now, this is the DOL's fact sheet on how this should play out. We're going to go to another fact sheet that's going to seem inconsistent with this result, but we can rely on the DOL fact sheet. It's persuasive authority to courts. And so if we carefully tailor our bonuses to reflect a system like this and treat everybody with unpaid time the same way, we may have a successful result here. Here's the difference. So, and this always strikes me as inconsistent, but this is the way the DOL views the world. That's not to say the DOL is always inconsistent. So we have Francesca. Everyone who has a late start gets a point, right? This is what we call a no-fault attendance system at work. It doesn't matter why you're late, you get a point. And so Francesca has a disciplinary warning because she received 3 points for being late to work on 3 different occasions. One time she was late for work, she was using FMLA leave to care for a child. Is this the right result? We treat everybody the same. And if we look back here, whoops, for our other slide, we were okay with treating Ray and not getting him the bonus because we treated Kathy the same way. We have a different result here though. The DOL says, hey, you cannot have a no-fault attendance policy with FMLA people. So you can have it in general, but if somebody has an FMLA absence, even though you would ding everybody else in a similar circumstance, you cannot ding for the FMLA absence. So in this case, Francesca can have 2 points because the other 2 absences don't appear to be FMLA qualifying. But the absence that she took that was FMLA qualifying, she cannot be dinged for with an attendance point. So the employer is on the wrong side of the law if they have a no-fault attendance policy and they don't account for FMLA leave by waiving essentially that no-fault attendance policy on FMLA days. Let's go to the next example. And there's a couple things I want to point out about this. Parker uses FMLA leave to go with her spouse to a prenatal care appointment. What's the first thing you notice about this example? This is a same-sex couple, okay? Parker comes back to work, her supervisor. So the DOL has intentionally set this up as a same-sex couple, and that's okay. Same-sex couples have the same FMLA rights as heterosexual couples. Doesn't matter. Doesn't matter that Parker cannot be biologically related to the child the spouse is carrying. Doesn't matter, okay? Still an FMLA event. Parker's not getting medical treatment, right? Parker is presumably just going along with her spouse. Does that qualify? Absolutely, it qualifies as FMLA leave because FMLA leave is available for the emotional support of anybody who's a qualifying family member. So my spouse may be perfectly capable of going to the doctor by himself. In this case, Parker's spouse might have been perfectly capable of going to a routine, presumably, prenatal care appointment by herself. It doesn't matter. It's still qualifying because all Parker has to say is I'm there to sort of support my spouse. She wanted her hand held, whatever it is. It's going to qualify. Emotional support qualifies. All right, Parker comes back. Her supervisor threatens that she will not be considered for a promotion if she continues to use FMLA leave because of her spouse's pregnancy. Are they on the right side of the law? Not by a long shot. Many issues here, as we've pointed out. Doesn't have to be biologically related. Same sex is okay. Emotional support is more than enough. And please keep that in mind. I saw employers all the time miscue that one, that, hey, just because Anne's going to the dentist doesn't mean her husband needs to come along. Maybe I have a fear of the dentist. We can, now it would have to be a serious health condition for me. It just can't be, I'm getting my teeth cleaned. But there may be situations where whatever appointment I'm going to rises to the level of a serious health condition, and you need to let my family member come along, my spouse, to help care for me. So always keep that in mind. All right, that's the end of our slides and the end of our time. If anybody has any questions, please let me know. And I'm happy to answer. Otherwise, keep in mind cocktails and compliance in August, and we should have some fun then as well. We'll talk about real life employment situations and how to handle them. Okay, thanks everyone. Have a great day. Oh, I think I have one question here. Let's see. No problem. Happy to help. Glad it was useful information. Take care, everyone.